Thank you very much, Representative St. John. I thank the panel of witnesses for their testimony. I'm going to remind the members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask the witnesses. I would also point out that given the number of bills and witnesses we have, we recognize that we might not get, in fact, I understand that I might not get to all the questions and witnesses that I would like to ask of the witnesses, that we do have the ability to submit written questions later. I will start by recognizing myself for 5 minutes. Chief Langford, I wanted to go back and think about the manner in which the United States broke its treaty promises to the Miami Tribe of Oklahoma regarding the land in present-day Illinois. And you pointed out the history of the broken promises, the broken treaties. But your statement also then highlighted the fact that there are now clouded property titles for private landowners in the historic Wabash River watershed. How would the legislation, could you just clarify again how this legislation will resolve the uncertainty facing these private landowners?
Madam Chair, this is somewhat of a risk for my nation, this bill, because we are willing to give up the claim for our day in court. But just because we get our day in court, if this bill passes and the president signs it and we get it signed, that clears cloud on title because we give up the land claim. And so all this bill grants to us is our day in court, and we still have to prove our case. But the landowners in Illinois, they receive, once it's signed, they receive immediate relief.
Right, and your testimony suggesting what Representative Young had said, that you have made the calculation that you need that day in court, and so you are willing to take that risk. And you've stated it again now, is that correct?
That is correct, Madam Chair.
I'd like to turn to the now to the chairman of the Klamath Tribes with regards to the difficulties that you are having with regards to having a say in how the benefits from the judgment fund are distributed to individual members. Your testimony pointed out the fact that many of those who should have been entitled to are passing away. And as you're looking at that judgment fund, can you tell us whether the Klamath Tribes have a way of preventing non-native heirs from receiving payments from the tribal fund?
No, the Judgment Fund Act itself states that the funds would be distributed to 1954 members and their heirs. So we don't have the opportunity to exercise our sovereign authority and discretion to do what our memberships have voted to do. And that's voted to support providing those remaining funds, which came about at a time that were approved by our 54 members for the litigation use. And then there were some funds that resulted, some unclaimed funds that are subject to this. So we would be required without this repeal of the Judgment Fund Act to follow that act. And our members have supported the 54 members themselves, a subgroup or sub-entity of the Klamath Tribes, voted to use those funds, which they authorized for the litigation purposes back when that was in play. But while there's still some remaining Docket 100 cases, they're the ones that allowed those funds and received those funds to be used for the litigation purposes. So we wouldn't have the ability to do what our 54 members voted for, and our general counsel as a whole have voted for in support of our 54 members to provide those funds to the living, surviving 1954 members.
Thank you.
So we would be, okay, I think that answers it. Thank you.
Thank you so very much. I now want to turn to the Honorable Cheryl Kennedy, Chairwoman. You this bill brings to our attention of this committee, like many of the other work that we do, that we're trying to rectify an error that the U.S. government made in years past. This is something that we have to deal with, like how do we fix these mistakes, these clerical errors, these unintended, with the unintended consequences that were really not meant to be. Can you talk to us about the history behind the drafting error that occurred before the Grand Ronde Reservation Act in 1994, and how that actually was conflicting with the intent of the legislation at the time?
Sure, thank you. I appreciate the question. The correction of the survey error came about when the BLM, of course, we worked in concert with them, and they came forward and identified that this error was existing. They actually brought the information to us. And so a negotiation started between the BLM and the Confederated Tribes of Grand Ronde on how we could make whole this error that was made well over 100 years ago in 1871. So that negotiation started, and we know that our reservation has not been fully surveyed, so there are probably errors that we don't even know about yet. So that's the history behind it.
Yeah, thank you so very much. I see I have run out of my time, so I am not going to have a chance to ask for additional clarification on the clerical error with regards to, that was raised with regards to the Samish Indian Nation. But I yield back but the time that I no longer have, and I will now recognize the Ranking Member Obernolte.
Well, thank you, Madam Chair. I would like to start with some questions about HR 6181, and let me begin by saying that we who serve on this subcommittee do so because we are passionate about advancing the sovereignty of the tribes in the United States and solving the legal problems that have arisen over the years that prevent them from utilizing the lands that they're entitled to. And for me personally, nothing's more heartbreaking than seeing the times when our ability to do that is impeded by tribes not being able to get along with each other. So, I mean, hopefully we can catalyze, some discussions about that. Let me start with a question for Ms. Napiahi, and the only reason I got that right is because of the instruction from you, Madam Chair, but let me point out it's no more complex than Obernolte. So could you describe, you talked about the concerns that you had as a tribal entity with this bill as regards your tribal sovereignty. Could you talk about the revisions that the Tulalip tribes and the other Washington tribes are proposing that would address your concerns with this bill?
Yes. Representative Larson introduced a bill in the 116th Congress. Tulalip and others concerned tribes offered revisions that would have allowed Samish to acquire the 6.7 acre parcel into trust status, while including language that makes clear no treaty rights of any tribe would be affected. We never heard anything back from Samish after offering those edits to them. Before that, Tulalip and other tribes offered amendments to HR 2320 in the 115th Congress that would have had multiple parcels of land legislatively acquired into trust for Samish, while similarly including language that treaty rights are not affected. Samish rejected those revisions also. In each case, Tulalip and other tribes provided revisions that would have provided for land to be acquired into trust for Samish. So the assertion that the tribes have obstructed Samish's ability to get land into trust is simply not true.
All right, thank you. So next question for Mr. Wooten from Samish. Would the draft ANS that we're considering today allow Samish to obtain hunting or fishing rights through the courts or by any other means, in your opinion?
No, sir, it would not. Those rights have been decided by the courts multiple times in different arenas, referenced in the Tulalip testimony about the the U.S. Supreme Court case. So no, in no way does this bill impact treaty rights for any other tribe. It just reaffirms our ability to take land into trust under the current administration following the Carcieri analysis or impacts from the Carcieri case.
Okay, so it seems like this should be simple, because the other tribes say they have no problem with you being able to take the land into trust. You say you have no problem with having that affect another tribe's treaty rights. So would you be willing to accept language that would resolve this and make the other tribes comfortable by confirming that, that their treaty rights are not going to be affected?
Ranking member, we believe that the ANS suffices, and it should make them more comfortable with the land going in trust for the tribe.
I mean, sir, you just heard testimony that they're not comfortable, and it seems like since we're all in furious agreement here, that the path of least resistance should be, let's get some language that clarifies what we all agree on and makes everyone comfortable, so that we can go back to advocating for your rights rather than trying to mediate a dispute between tribes.
So again, ranking member, we believe that the language is necessary to protect the tribe's previous feeder trust application, because it was taken in before the 2009 Carcieri opinion happened. And yeah, that's why that language is there. That's why the reaffirmation of the IRA is there, is to protect the existing tribal lands and the 6.5 acres going into trust.
Forgive my frustration, but we see this all the time. And the problem is when the tribes can't agree to get along, when everyone has the same goal, then what happens is everyone loses because legislation can't move forward. So I'm hopeful that maybe we can reach some language that everyone can agree with, since we all agree on the principles here. I see I'm out of time. Madam Chair, I yield back.
Thank you.
Thank you very much. The chair will now recognize the representative from Arizona, Mr. Gallego.
Yes, thank you, Madam Chair, and I'm also the sponsor of this legislation that has been ongoing for a couple years and has gone through multiple revisions, as well as amendments that we have taken in from tribes, not just Chileans, but other tribes, and have been quite accommodating. So we will continue to work, but to be clear, this is the accommodation. Vice Chairman, I have great respect to Toledo Tribe. I've actually worked with many of your tribal chairmen in the past, both in the private sector and in the government sector. And just want to say thank you for being here. I'm encouraged by your testimony that your tribe does not oppose the Samish taking in the 6.7 acre parcel. However, in order to do that, the tribe must use the IRA, Indian Reorganization Act. Like many tribes, Samish has been kept from doing so by the Carcieri versus Salazar decision, which is in part why I introduced this bill. Does your tribe support a Carcieri fix to allow Samish and other nations like them to take land into trust?
Tulalip, like many other tribes that have not had the Carcieri decision prove an obstacle, has not taken a formal position on the Carcieri fix bill because we haven't needed to.
So so unlike the hundreds of the tribes I've spoken to in the past 8 years that I've been on this subcommittee, the Tulalip are not for a Carcieri fix?
We're neutral.
You're, okay, well, that's interesting. Chairman Wooten, last Congress, I chaired a hearing on the Samish Indian Nation Land Reformation Act. This year, we're receiving testimony on a revised version of this bill that I worked on with the Samish Nation to further simplify the bill and address any lingering concerns. And I say again, any lingering concerns. Chairman Wooten, can you explain in more depth why Samish is seeking this ANS to the bill and what this ANS would do exactly?
So again, thank you for the question, Congressman. The bill is what it is. It's about taking land into trust for the Samish Indian Nation. As I explained in both my written and my oral testimony, that the tribe has had a long, tortured history dealing with the federal government. And this would give relief for us for future applications to be considered to take land into trust for the nation. And that's all we're trying to do here. It's about land into trust. It's not about treaty rights or anything else. It's just about land in a trust.
Thank you, Chairman. I just want to also clarify, our bill reaffirms the application of the IRA to the Samish because of the 79 acres of trust gained by the Samish tribe before the 2009 Kachiri decision. The IRA has already applied to the Samish in the past. So this bill no longer mentions the 2018 DOI decision, which was, by the way, one of the things that some of the opposing tribes asked us to do and incorporate. So that's why it's actually on this ANS. So even if it did, it would not threaten treaty rights, which are settled law. Chairman Wooten, in our conversations and in conversations with our offices, how many times do you think we actually incorporated some of the opposition's viewpoints into this bill?
Congressman, I would say every time that we received comments, we considered those and incorporated what we felt was applicable to the language of the bill. And of course, as you well know, the bill has changed several times. As the administration has changed, the rules, if you will, for land into trust has changed. And then, as you mentioned, in 2009, the Carcieri court case changed everything. And we were caught up in that. And again, it took us 9 years to generate the determination or the report for the BIA to consider us to even take land into trust.
And Chairman,
Yes,
can you
we've tried to accommodate.
let me gain my time back because I want you to elaborate on the quote-unquote clerical error that occurred by the BIA in 1969, which effectively left the Samish off the list of recognized tribes. What is that clerical error?
So again, the tribes up here in the Northwest are, there's 29 tribes in the state of Washington. In 1969, the Bureau transferred, a low-level clerk transferred the list of recognized tribes from one page to another and left off several tribes, which, well, 4 of them. Samish was one of those tribes. We did not discover that until 1973 when the US v. Washington case happened. So yeah, we've been fighting for this my whole existence as a tribal leader.
Thank you, Mr. Chairman. Madam Chairwoman, I yield back.
Thank you very much. And the chairwoman will now recognize Representative Radaragan.
Talofa, good afternoon. Thank you, Madam Chair, and Leisure Fernández and Ranking Member Obernolte for holding this important hearing today. Thank you to the witnesses for testifying. My questions are for you, Chairman Beretta. As your testimony indicates, while the issue is very important to the Alaska Native elders, the bill would help, the number of Native elders affected by H.R. 437 is quite small as a percentage of all Alaska Natives, correct?
Yeah, the life expectancy of our Alaska Native people is fairly low, and so from our corporation, the number is small.
Thank you. I realize there are a number of Alaska Native regional corporations, of which yours is one, correct?
Yes, we're one of 12.
And there are even a greater number of Alaska Native village corporations, as I understand it. But my question is, has your Native corporation actually experienced a situation where your elders have turned back settlement trust benefits?
We have had elders, yes, thank you for the question. We have had elders who have asked if they should give their shares away because the benefits that they were receiving were in jeopardy. And this is very troubling because a lot of these elders' benefits go towards basic needs for these for food and for glasses and just day-to-day benefits for these elders that live in these remote communities.
Thank you. Now, this question is for Cheryl Kennedy, Confederated Tribes of the Grand Ronde. Some tribes have expressed concerns to the committee that the gaming prohibition language contained in the bill would not exclude monetary awards from a land claim settlement that then could be used to purchase land for gaming purposes and use the Land Claim Settlement Act exception in the Indian Gaming Regulatory Act. Now, would you support amending the bill to address those concerns?
Thank you for the question. I believe that that question has been responded to in the long report that has been submitted. Again, reiterated during my oral testimony today that we have agreed that that any settlement funds or any potential transfer of funds would not be used for gaming purposes. And I go on record right now in reiterating that that is not what those funds would be used for. Thank you.
So, the Department of Interior has previously testified on the legislation, expressing concerns regarding the legislative history. Have you worked with the department since the 2020 hearing to resolve those concerns?
There has been correspondence between the agency and the Confederated Tribes of Grand Ronde. I believe at our hearing with the House, there was no opposition that was raised. So all of the issues that may have been there have been dealt with. Thank you for the question.
Okay, and this question is for Don Gentry, Klamath Tribes. Your testimony notes that the BIA and the tribe have made strenuous attempts to locate tribal members who were entitled to funds in the Klamath Judgment Fund. Can you elaborate on those efforts?
Yes, there are two different funds. There was significant effort on the unclaimed funds that was done by the BIA, and their responsibility to address unclaimed funds as a result of the litigation funds that were available. And so they exhausted and fulfilled their obligations to allow those funds to be potentially transferred to the Klamath Tribes. In addition, the Klamath Tribes, our folks have been interested in trying to help. So we've actually published several times in our tribal newsletter and got information out to our members, listed the names of the folks, the family names and the individual names for those unclaimed funds. So when we did that, we know we've gone beyond. In terms of the litigation funds, there was quite a bit of discussion on how to do that. If the litigation funds, which haven't been distributed, were to be distributed by the BIA, there would be an exhaustive effort to locate all the members and the shares and their heirs. And basically, there'd be a lot of money expended in that process. So that hasn't really been done. What we believe is appropriate is, since those funds were authorized for use by our 54 members, and we believe those funds should be under the authority or the direction of what the 54 members want to do. So we're intending to, if this legislation passes, distribute those funds. We take that burden upon ourselves and distribute those funds to the living 54 members and not go through an exhaustive process.
Thank you so much, Mr. Gentry. I'm way out of time. Thank you, Madam Chair.
Thank you. The chair will now recognize Representative Garcia from the state of Illinois.
Thank you, Madam Chair and Ranking Member, and to the witnesses who are with us today. We're here to discuss several tribe-related bills, many of which seek to rectify past wrongs. Committing to justice, however, requires more than merely acknowledging the mistakes of the past. While the legacy of injustices against Native Americans remains alive today, these bills are a first step towards achieving necessary measures of accountability. I'd like to begin with a question for Chief Langford. Thank you for being here and shedding light on a chapter of our country's dark history and the removal of your tribe from its ancestral homelands of the Great Lakes region. Can you share what HR 6063 to provide for the equitable settlement of certain Indian and land disputes regarding land in Illinois means for the Miami tribe of Oklahoma, and what challenges remain even if the bill were to pass?
Well, well, thank you for the question. The challenge is there's still a court case that we would need to prove and prevail. And so, that's really the last challenge, is to prove our case in court, which uh, I wouldn't ask to get this law done if I didn't think we could not prove that case. So that's the biggest hurdle, is once the law becomes law, is to take this and go win our case, which we very much intend to do. I would, if I might make a statement, there was a mention by the ranking member about gaming. This bill has nothing to do with gaming, and I don't believe it has any bearing on the gaming. So I just would like to enter that. Thank you.
Thank you. And in your testimony, you describe that Congress has passed, quote, numerous judicial bills over the prior decades. HR 6063 is unique, close quote. Can you describe why HR 6063 is a different approach than previous bills and why Congress must pass this now?
One of the main reasons this is completely unique is the U.S. never purchased or ever paid anything for this land. It was never, we didn't cede it, and it was never paid. The tribe was never paid. So that makes it somewhat unique in that it was somewhat overlooked by the U.S. And the other unique thing about it is it helps the landowners in Illinois by clearing their title. That's one of the unique things that this bill does. It doesn't just help our nation, it helps the landowners in the affected area. That's what makes this very unique.
Great, thank you. For Senator Tamara St. John, thank you for joining us. Although the federal Indian laws of today uphold the principles of tribal self-determination and sovereignty, many enacted laws that reflect the prior federal areas of genocide, removal, assimilation, or termination still remain in the U.S. Code. Can you tell us, Senator, why it's important for Congress to pass S789, the Respect Act, despite federal Indian laws of today being vastly different from the outdated racist laws of the past?
Thank you very much for the question. I feel that it's very important because when you look at these particular sections of legislation where they speak to things that are like withholding rations or money, if a person were not to allow their child to be sent to boarding school, or in case of use of intoxicating liquors. Some of these things I think are so atrocious when you look at the details of them, that it really does need to, these are things that I believe, of course, they're not enforced today. There would be a huge outcry if these things were enforced. But these are things that are very real when we work with history, such as Carlisle Boarding School. That's been an ongoing thing. And to know that rations were withheld, or our children were held in boarding schools as a condition to the negotiations in a treaty. Those sort of things play into these too, and it would be fantastic. It would be a great start.
And in 5 seconds, what would passage of the Respect Act mean for you and the Dakota tribe?
I think it would mean that, first of all, it's acknowledgement of that these still exist. And the acknowledgement, it would signify a change to do better. I think that that's very important.
Thank you so much, Madam Chair. Thank you for your indulgence. I yield back.
Thank you very much. The chair would now recognize Representative Rosendale. Hello, for your 5 minutes. Now recognized for 5 minutes to question the witnesses. We can now move and recognize Representative Schroeder. If the witnesses would have patience for about another minute, we understand that the representative is on his way. Welcome, Representative Schrader. That's fine. We will now recognize you for 5 minutes to question the witnesses. Welcome.
Can't hear.
That does help. Jeez. All right, the bill concerns 84-acre Thompson Strip, piece of Grand Ron's original reservation lands that was erroneously excluded in an 1871 survey of the reservation. And because it was not included in the survey of the reservation, the Thompson Strip was also excluded from a 1904 sale of the unallocated lands within the reservation, and Grand Ron was not compensated for it. Bureau of Land Management held the land and allowed 3 different private companies to harvest land and harvest timber on it, profits from which the tribe never saw any benefit. The tribe thus lost 2 avenues of compensation because of this simple survey error back in the day. BLM discovered the problem in 1988 and arranged a land exchange with Grand Ron in which the tribe would receive 240 acres of BLM land contiguous to the present Grand Ron Reservation in exchange for relinquishing their claim to the Thompson Strip. The land exchange was agreed to by the tribe and the Oregon BLM office as a dollar-for-dollar compensation for the Thompson Strip sale and lost timber income. In the 1994 legislation to effectuate this land exchange, the land was erroneously inserted that was erroneously inserted that relinquished Grand Ron's right to bring any land claims in the whole state of Oregon, not just the Thompson Strip. No other tribe in Oregon has had their land claim rights extinguished for the entire state. The current statute is far broader than the tribe, BLM, or Congress or my state ever intended. The tribe's congressman at the time, Representative Mike Kopetsky from my district, confirmed his understanding about the land exchange and the extinguishment of claims to the Thompson Strip and testified before the same subcommittee, saying, under this bill, the tribe will relinquish their claim to the 84 acres in exchange for a parcel of 360 acres, later revised to 240, of BLM land, which is adjacent to the tribe's current reservation. Congressman Kopetsky's clear intent was for Grand Ron to give up their claim to the Thompson Strip, not all the lands in the state of Oregon. Mark Mercier, then chairman of the Confederated Tribes of Grand Ron, testified at the same hearing as Congressman Kopetsky. His testimony again makes clear that Grand Ron intended to relinquish their claims to this land that was incorrectly surveyed and makes no mention of the rest of the state. Ron Scherler of the Oregon State BLM wrote in June 1994 memo that the land exchange bill should not extinguish all land claims in the state of Oregon and should apply only to the Thompson Strip. In agreeing to this land exchange in 1994, the intent of the parties was for Grand Ron to relinquish its rights only to this strip, I keep saying that, and any claims for lost timber income. There's no intention to relinquish all rights. This bill would change the statute to that and read that the Grand Ron relinquishes all claims to the Thompson land, not all lands within the state of Oregon. It's carefully written, the technical fix, trying to eliminate any possibility of unintended consequences or changes in land use. The bill would prohibit specifically Class 1 or Class 2 gaming, Class 2 or Class 3 gaming on any land or on any land claim settlements that the tribe obtains to allay all concerns on casinos. This amendment to the Grand Ronde Reservation Act, simple, hopefully not controversial. The Senate passed S559 on May 26th. The House Natural Resources Committee held a hearing on the identical House version of my bill in the last Congress. Time to pass the legislation and correct this historic wrong once and for all. Thank you very, very much, Madam Chair.
Thank you, Representative. The chair will now recognize Representative Rosendale for 5 minutes, if you choose.
Thank you, Madam Chair. And I appreciate all of the witnesses and bearing with us, as now we are back in an active Congress, I will call it. So everybody's schedules are getting filled up again, and I apologize for not being here for more of the presentation. I do have a question for Don Gentry with the Klamath Tribes. If any of these individuals or their heirs' whereabouts are eventually known after the enactment of Senate 314, would they have a claim against the United States?
I don't believe so. I think the Bureau of Indian Affairs and their responsibility in finding the individuals is since passed. So, basically, folks, if they try to come after the fact, after the deadlines and the process is passed, they wouldn't have a valid claim.
Okay, that's, Madam Chair, I would yield back. Thank you so much.
Thank you very much, Representative. Before we conclude with the witness panel, are there any members who have not had their 5 minutes and who seek recognition to ask questions now? Then I thank the witnesses for their valuable testimony, for their patience, and I thank the members for their questions, which helped illuminate the issues over how do we address these issues so that we can correct those clerical and other errors that we have had in our history with regards to our relationship to our tribes and Native Americans. So as I stated before, the members of the committee may have some additional questions for the witnesses, and we will ask you to respond to these in writing. Under Committee Rule 3.0, members of the committee must submit witness questions within 3 business days following the hearing, and the hearing record will be held open for 10 business days for those responses. If there is no further business, without objection, the subcommittee stands adjourned.